You're watching The Legal Breakdown. This is our second video covering day one of Donald Trump's first criminal trial in New York. Glenn, I gotta ask first, before we get into the meat of day one, what's your reaction to Donald Trump falling asleep in the courtroom?
You know what, Brian? Not a good look when a defendant who is sort of fighting for his life, albeit figuratively speaking, fighting to remain a viable candidate for the presidency, fighting to potentially stay out of prison, isn't interested enough to stay awake on day one of his trial. There was reporting from Maggie Haberman and others that multiple times, the head went down, the jaw went slack, and he was out. In fact, a note was being passed to Donald Trump by his lawyer, and he wasn't even taking it because he was out. And then I guess the head reeled back one time, and he caught himself after he'd fallen asleep. Not a good look. You would think you would have enough interest in what was going on that you might want to stay awake, you might want to pay attention, you might even want to participate in your defense, but, not Donald Trump. So now, let me say, having litigated some very lengthy trials, I have seen all sorts of people fall asleep in the courtroom. I've seen jurors fall asleep, at which point the judge has to sort of gently say to the jury, might this be a good time for a break? So everybody kind of, wakes back up. So it's not that unusual. But the defendant falling asleep, let me just relate this story that just occurred to me. We have kind of a saying, anytime somebody is being interrogated, a custodial interrogation after they are taken into custody, the detectives or the agents or the investigators will be going at them, and then they'll take a break and they'll walk out. But the video recording keeps rolling, so you can see the defendant sitting in the room. An innocent person who's being interrogated will be awake, will be alert, will be bouncing off the walls, but a guilty person, when they get that minute to take a break in the interrogation, will fall asleep every time. I don't know if that's what's at play here, but it was notable that, Donald Trump couldn't keep his eyes open.
And just quick, and before we dive into the rest of day one, just two things on the political perspective to this point. The first is that Trump has predicated his entire re-election campaign on this idea that his opponent, Joe Biden, is Sleepy Joe. And yet, while Joe Biden is crisscrossing the country and dealing with international crises in Russia and Ukraine and also the Middle East, you've got Donald Trump, who can't even stay awake during his own criminal trial, which one might think would be a pretty momentous occasion if it was happening to anybody else. So that's the first thing. The second thing is that, if he can't stay awake during his own criminal trial, is this guy going to be able to be awake at 3 o'clock in the morning if he needs to go into the Situation Room? Is he going to be awake if a natural disaster wreaks havoc on an American town or city somewhere in this country and he has to respond to it immediately? this doesn't bode well for the guy who's running for a job where you can't be nodding off somewhere just because you're bored. All right.
Yeah, I think Trump really did one-up Joe Biden when he's always referring to him as Sleepy Joe. We now have, drowsy defendant Donald, which I think is really a far more serious concern. The man is on trial for his freedom, and he can't stay awake. Come on now.
Perfectly put. All right, Glenn, so let's dive into some surprising news from the courtroom here. Judge Merchan asked the pool of 96 prospective jurors to self-identify if they should be excused if they don't think they could be fair and impartial. Of those 95, about 50 of them raised their hands, and they were then excused. What's your reaction to that?
My reaction is you probably have 50 honest jurors who said, I have such strong feelings one way or the other about Donald Trump and what he's done that I just don't think I can be fair. And you know what? Those are the people we want to self-select and be dismissed, right? We want fair and impartial jurors, people who themselves, deep down, subjectively believe they can be fair and impartial. Maybe they're not terribly political. Maybe they're not terribly plugged into what Donald Trump has done. Maybe they don't have strong feelings one way or another. I know it's kind of hard for us to understand that, given what we, the people, have been subjected to at the hands of Donald Trump for the last 6, 7, 8 years. And yet there are people out there like this. It's a really interesting choice for Judge Merchan, however, to let jurors self-select and opt out. Why is it interesting? Because, Brian, there are a lot of people who just don't want to be bothered with jury service. We've all kind of we've probably heard the joke that I would never want to be judged by 12 people who weren't smart enough to get out of jury service. A lot of people, in my experience, and I picked a lot of juries, will try to come up with BS reasons why they can't serve because they just don't want to be there. I think what Judge Merchan did, though, letting people completely opt out and go unquestioned in their assertion that they want to opt out, that they can't be fair and impartial, I think it was the right call. Why do I say that? Ordinarily, that's not the way it happens. If somebody wants to opt out, you know what we almost always do? We question that jury. We ask, well, why is it that you think you can't be fair and impartial? Some people might say, you know what, I've had really bad experiences with the police or with a prosecutor or with the judge, and I don't think I can be fair. Or I've had a really bad experience with a defense attorney, and I don't think I can be fair. And we will question that person to see whether they're maybe overstating the case, whether they can be fair. Let me just use one example, which I think is a really important illustration of this principle, how we ordinarily try to rehabilitate a juror who thinks maybe they can't be fair. I did a lot of murder cases and a lot of murder-driven RICO cases of violent crime organizations. And sometimes jurors would say, you know what, Judge, I don't think I can be fair in this murder case because the murder was committed with a firearm. That's the information that the judge gives to the jurors up front. The judge will put the jurors on notice of the nature of the case. And I have such strong feelings about firearms, either one way or another. But let's assume the juror says, I am so against firearms that I can't sit fairly as a juror in a case if it involves a firearm, if it's a shooting death. We would try to rehabilitate that juror, and we might not be successful. Here's what I would say to that juror. I would say, sir, so are you saying that if the prosecution's case didn't prove the defendant's guilt beyond a reasonable doubt, you might vote guilty anyway because you heard evidence about a firearm and you really don't like firearms? You know what most jurors would say in response to that, Brian? They'd say, yeah, I never thought about it that way. No, I guess I could be fair even though I really don't like guns. That's called rehabilitating the juror. We try to do it as long as we can get the juror to a place where they honestly believe and we honestly believe they can be fair, even though they have these aversions or these preferences. Judge Merchan said, I'm not going to do that. Why? Because it would probably waste lots and lots and lots of time trying to rehabilitate people who really can't be fair when it comes to Donald Trump for one reason or another. So, but it does make it seem like, you know, the jury selection is going to be an uphill slog. They called for 96 jurors on day one, 50 self-selected out. It's going to take some time to impanel 12 jurors and I think 5 or 6 alternates.
Glenn, I want to read a quote that Adam Klasfeld posted on Twitter, and this is from a juror. Quote, I feel that nobody's above the law, whether it's a former president, a sitting president, or a janitor. Is a quote like that grounds for disqualification from a juror? Like, and as a follow-up to that, what does it say if it is grounds for disqualification?
An answer like that, Brian, is grounds to qualify a juror. We can never come to a place in this country where a member of the community is called for jury service and they say, I believe in the rule of law. I believe everybody should be treated fairly and equally under the rule of law, regardless of their station or status in life. That qualifies a juror. It doesn't disqualify a juror. And I can promise you, there is no way Judge Merchan would grant a defense motion to kick that juror off. It's called a challenge for cause. You get an unlimited number of challenges for cause as the defense attorney and as the prosecutor, because if there is cause to kick somebody off, then they should be kicked off. After you've exercised all of your challenges for cause because you think a juror has said something that indicates they can't be fair, then you move on to the next step, and that is what are called peremptory challenges. Each side gets 10 challenges, and they can kick off anybody. So, for example, that conversation we just had about that juror's answer, that I believe the law applies equally to presidents, former presidents, and janitors, the defense attorney might say, well, I can't really challenge that person for cause, but I'm going to use one of my peremptory strikes to get rid of that person because they're just too darn fair. You know, but that is, you know, the prosecution wants to get jurors on on the panel, on the jury, who can be fair and impartial. Now, let's be clear. We want people who are a little bit pro-government, a little bit pro-law and order, a little bit equal application of the law for everybody. But the defense is not looking for a fair jury. What the defense wants is one thing and one thing only: people they think will, vote Donald Trump's way and find him not guilty, not because they're fair, open-minded jurors, but because maybe they do have some biases or prejudices or preferences.
Right, expressly because they're the opposite. Glenn, I'm going to read you the Parker warning here. You have the right to be present during the trial and to assist your attorneys. Do you understand? To which Trump replied, yes. Judge Merchan said, if you disrupt the proceedings, you can be excluded from the courtroom and committed to jail based on your conduct, and the trial will continue in your absence. Do you understand? Trump said, I do. Judge Merchan said, if you do not show up, there will be an arrest. Do you understand? Trump said, I do. Well, what will the implications of this warning for Trump be, and how serious are they if they're violated?
Yeah, so these are standard warnings that are given to defendants, every time a trial commences. The judge will put the defendant on notice that, one, you have a constitutional right to be present at every single hearing in your criminal case, and in fact, you are required to be present. I, as the judge, will not waive your appearance in a criminal trial, unlike in a civil case where defendants or respondents don't have to show up if they don't want to. And that's an important constitutional right, the right to be present at your trial. However, once a trial commences, and the definition of the word commence is the minute that 12-person jury plus the alternates are sworn after jury selection, that is the commencement of the trial. If you absent yourself, the trial can continue in your absence. Interestingly, if somebody jets, somebody flees before the jury is sworn, before the trial technically commences, the prosecution cannot move forward in the trial. They have to go out, apprehend the defendant, bring them back to the courtroom. So these are kind of standard warnings and legal principles that a judge will instruct the defendant on. So if you leave, if you don't show up after the jury is sworn, one, you can be locked up. Two, a trial can actually commence in your absence. And three, if you are in court and you disrupt these proceedings, you can be thrown in jail and, the trial can continue forward. So these were not, they sound very ominous, and they are. This is serious business, but these are also just kind of standard principles of law that all defendants are put on notice of, so they know the consequences of leaving and not coming back, and they know the consequences of disrupting the proceedings.
All right. And now, was there anything else that stuck out at you from day one that was either unusual or striking?
It's just that the defense attorneys seem to be losing every battle. Now, that's not wildly unusual, but in my experience, when I'm litigating a case, the defense is winning some of the motions, and the prosecution, I'm winning some of the motions, but they have, maybe it's in part because the motions they have brought, many of them, seem to be a product of Donald Trump saying, I want you to keep Michael Cohen off the stand. I want you to keep Stormy Daniels off the stand. The reality is the law doesn't permit judges to rule witnesses can't testify. It's just kind of a stupid issue to raise with the court. But, Donald Trump seems to be king of the stupid issues and insisting that his attorneys raise those stupid issues. So they are losing. Michael Cohen can testify. Stormy Daniels can testify. Interestingly, the one they seem to have won, at least in part, was the Access Hollywood tape, where Donald Trump said, I just walk up and I start kissing them. I don't ask for permission, and I can grab them by the you-know-what, because when you're a star, they'll let you do it. The prosecution said, Judge, we want to play that Access Hollywood tape for the jury. The judge ruled, it's so prejudicial. It could so inflame the jurors against Donald Trump for reasons other than the issues in this case that I'm not going to permit you to play the tape. But you know what he did rule was admissible? An email where the entire substance of what Donald Trump said on the Access Hollywood tape will be coming into evidence, so the jury will know what he said, even if they don't see with their own eyes him saying it. So the one thing that I find surprising is the consistency of the defense losing.
And let's finish off with this. Based on how quickly voir dire was taking place today, how many days do you think this entire process should take before the full jury of 12 folks is impaneled?
I think things will begin to move a little bit more quickly. My experience is you kind of settle into a trial pace after the first day or two, and then things begin to move a little bit more efficiently once all the parties have kind of felt each other out and they know how, you know, each other operates. So I'm still thinking jury selection will probably take somewhere between 1 and 2 weeks, and then we'll jump into opening statements.
Okay. Well, with that said, for everybody watching right now, Glenn and I will be doing exhaustive coverage of this entire trial. So if you're watching right now and you want to follow along, please make sure to subscribe. I'll put the links to both of our channels right here on the screen. So just hover over those links, click the subscribe button, and you can follow along with the entirety of this trial. With that said, I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.